Hello, how's it going?
Morning, how are you?
Good, good.
Are we expecting anybody else from the applicant side?
I I under the impression my architect Matthew Evans is supposed to be here, but if he's not, I can speak to
Oh,
it.
he's here. He's
Oh,
here.
great.
All right. All right, let's go ahead and get started. First thing I'm going to do is I'm going to check everybody in just so we know who's all here. I have labeled Kylie's iPhone. What's your name, sir?
Kylie O'Connell.
Kylie O'Connell. Gotcha. And you are the owner of the property?
That's right.
Okay. And then I have Matthew Evans.
Correct?
And you're the architect on the property?
Yes.
Got it. All right, and we have Wes Munzel here from the planning department.
Good morning.
Good morning. All right, let's go ahead and get started. This is the July 30th, 2025 session of the zoning hearing examiner docket. My name is Ashton Tucker, and I will be serving as your zoning hearing examiner for the city of Cincinnati and be presiding over this hearing. The case before us today is case number ZH20250067 involving the property at 3440 Principio Ave. Let's see, the purpose of this hearing is to allow applicants and any other parties to testify and to offer and refute evidence and testimony. This hearing will follow the rules found in the zoning code as well as the supplemental rules of the zoning hearing examiner. All testimony and evidence that an applicant or any other party wishes to offer must be presented at this hearing. The hearing will proceed as follows. The applicant or the applicant's agents will first present the applicant's case. If the public were present, the public would have an opportunity to respond and speak after the applicant has presented his case. Then the zoning plans examiner who produced the staff report regarding this application may provide any testimony. In the event that any party offers argument or testimony in opposition to the application, the applicant will have an opportunity to rebut that testimony or offer their own argument in opposition of that opposition. After the applicant has been given an opportunity to rebut any testimony offered in opposition, I will give all parties an opportunity to make a closing statement. The applicant will have the final word. After all presentations have been made, I'll close this hearing and decisions can be expected within 3 weeks. I may limit or exclude any testimony that I deem irrelevant or outside of the scope of the application being considered. I may interrupt any speaker to ask questions or to make any comments. In the event of any technical difficulties, I may continue or postpone this hearing at my discretion if it's not something that I can fix on the fly. Okay. At this moment, all persons providing testimony must be sworn in. What that means is I do need you to be off mute. And if you could raise your right hand. Oh, you're still on mute, Kylie.
All right. Sorry about that.
That's all right. You raise your right hands. Do you all swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
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 Okay, thank you. Starting from the applicant side, who would like to lead on this?
Yeah, I can just give the backstory if that's all right. Sorry for technical difficulties. I'm on vacation. So we got a variance approved not too long ago and did the renovations on the house to connect the garage with to the main structure. And unfortunately, a tree from a neighbor's yard fell, crushed the garage completely, and damaged the house, but crushed the garage completely. And so we're trying to make lemonade out of lemons here and do a 3-car garage that's attached to the house. And I think Matt can correct me or Wes can correct me, but I think it's allowed. It's just that there's a few feet in the back of the third stall that we would be adding that is in dispute here. And all the neighbors I've talked to are in support of it. I think one of the neighbors emailed in. I got a text thread from the neighbor that's directly behind us, who's really the only one that would be visually impacted by this change, and she was all for it as well. So I think everybody from the neighborhood seems to be on board with what we were trying to do. But does that help give the background?
Yes, thank you.
Thanks.
Yeah, I'd like to add a few things if you don't mind.
Yes.
First, let me clarify the initial variance that was granted, I think almost 2 years ago now. Is that correct? Something like that, or close to it. The existing residence that the O'Connells have was built with a detached garage, located properly within the city of Cincinnati setback restrictions. That detached garage met the requirements for not only setback, but height and areas and square footage. And it was detached from the principal structure. We then were hired by the O'Connells to remodel part of their master suite, and then we came up with a way to link the garage to the house so they didn't have to walk outside, or they walked outside but covered. So we created a covered roof system that connected the garage to the house. All right. That was presented to the city. The city then approved it, and in the approval process decided to make the garage part of the principal structure. Rather than grant a variance for the attachment, they basically said, we're going to allow this building to be attached. We're going to allow the garage to be considered part of the primary principal structure. At that time, there were some comments from the public that they were concerned that the structure, that the owner would down the road put a second story on the garage and make the garage as massive as the house. And we told them at the time that that was not the intent, that the intent was to provide access to the garage so that they could use it as if it were an attached garage. The tree fell on the building. It destroyed the building effectively, and it has to be rebuilt. When we were approached to do that, the intent of this design is to make the garage still appear as a detached garage. So the design that was presented and has been applied for meets the criteria of a detached structure. So it still is the same distance away from the property line. We're still using the existing foundation that was there. It does not exceed the height. It does not exceed the allowable height for a detached structure, and it does not exceed the allowable area of a detached structure. So overall, we were doing the best we could to not only provide the owner with what they wanted, but appease the neighbors that had concern about this now primary structure becoming very, very large and very tall. So we still wanted the building to appear as an accessory structure. So basically what we're doing is we're taking what the city said was now part of the primary structure, but we still want it to look like an accessory structure. I hope that makes sense.
I think I get
So that was our intent. Now, when we submitted it, obviously the concern, what happened was Wes reviewed it, and he reviewed it as part of the primary structure. Now, granted, we've already got a variance to have the primary structure within 3 feet of the side and the rear property line. So that primary structure, now deemed by the city, is in conformance because of the variance that was previously granted. The zoning code says that I couldn't build not only within 3 feet of the property line, but between the house and the garage, because both those fall within the required setbacks for a principal structure. But at the same time, we've had a variance to approve that to be a primary structure already. So all we're doing is just providing the owner with their three-car garage they would like to build. But again, the intent here is to make it look like an accessory structure and do the best we can to conform with the city's code, but also appease the neighbors and their concerns from the original meeting.
Thank you very much. All right. Mr. Munzel, what would you like me to know from the planning department side?
Good morning. Yeah, this is a really complicated technical kind of review thing. So yeah, as the applicant and the architect have mentioned, there originally was a detached garage that they connected to the main house in 2024, which by default, then the detached garage becomes part of the principal structure and has to follow those rules. So they got a variance for that connection for the default location of the garage. So that's all good. Then the tree fell on the garage, damaged it. So then they came in with another proposal, and this proposal expanded the footprint of the building of the garage and also the height. So that's where the new variances kick in, is because of the expanded size vertically and horizontally. Although the vertical expansion is less than a foot, but we had to get that detail nailed down to be able to, account for that increase in the facade height or the roof height. Because that technically, changes what was there before. It's not the same as what was there before. So therefore they need new variances. So that's the additional information on the background. So our report did conclude, recommend approval. That's obviously a minor increase in the height of a few inches. And the size horizontally increased by 8 or 9 feet by 25 feet, I think it was. So, and then they connected the garage area to the house area with an enclosed hallway. So that's slightly different as well from the previous breezeway or covered roof or covered walkway design. But bottom line, it's conceptually the same as it was before, with the appearance as a detached garage. The massing and size are conforming to a detached garage parameter, as was mentioned. But by definition, it's part of the principal structure and therefore has to get these variances. So we recommended approval, finding that it's compatible with the neighborhood. It doesn't change the horizontal setbacks. And it's, very minor changes, but compatible with the area. So that was kind of our concluding thought there.
All right. Okay, we don't have anybody here from the public, so I'll just go directly into closing remarks. Anything before we close this out? We'll start with Mr. Munzel.
I don't have any further comments, no.
Okay, thank you. Anything from Mr. O'Connell or Mr. Evans?
No, nothing from me. Thank you, though.
Yep.
All I would say is we would really appreciate approval of this as soon as possible. The tree destroyed the building quite a while ago. Obviously, this is an ongoing process. It requires a lot of patience on the homeowner's part. I have photos of this with snow all over it. So this is something that's been going on for a while. So we'd like to get the process rolling on construction as soon as possible.
Yeah, that's a good point. The neighborhood, I'm sure, would appreciate the eyesore being fixed as well. So.
Okay, so what I'll do now is I'll close out this hearing. I will let you know that I am going to approve the application. However, I do have to formalize that in writing. That may take me a little while. I imagine it will be to you within the next 3 to 4 weeks, generally speaking. I'm trying to play catch up here, but I would say expected 3 to 4 weeks, okay?
Okay.
We appreciate it very much.
Thanks, all. Appreciate it.
Thank you, everyone. Have a great one.